single OVWI charge can change your life in Hamilton County. Now, some people call it a DUI, some people call it an OVWI. In Indiana, the law states it is operating a vehicle while intoxicated. So we're going to refer to it as an OVWI. And a few different charges for that and what exactly it can mean. So first, we'll look at the BAC levels, what you probably hear when you think about over the limit, under arrest. So in Indiana, there are two different BAC levels where they can charge you with different OVWI offenses. If you're operating with the BAC above 0.08, that's a C misdemeanor charge. If you're operating with the BAC above 0.15, it rises to an A misdemeanor. Now, there are two other charges we can talk about that don't have a BAC component. There's operating a vehicle while intoxicated, where the state isn't required to prove your BAC is above a certain level, but oftentimes that BAC level will help their case. There's also operating a vehicle while intoxicated, endangering a person. And we see this charge a lot, and people are sometimes confused. I didn't get in a wreck. Why am I charged with this? The endangering a person charge is charged almost every single time. And what it means is your driving behavior could have endangered yourself or another person on the roadway. So that's a common charge as an A misdemeanor that we see. Now, there are some felony charges for OVWI as well. One of them is if you have one of those misdemeanor charges and you had a prior conviction within the last 7 years. If that's the case, the new charge will be elevated to a level 6 felony. It's also a level 6 felony if you have a child in the car under the age of 18 when you operate while intoxicated. Finally, there's a felony charge where if someone is injured, it rises to a major felony. So all of those are going to be things that we look at. We're trying to see what you might be charged with. There's also a charge for operating with a Schedule 1 or 2 controlled substance or its metabolite in your system. And this is a very difficult charge to defend because the state doesn't have to prove you were even intoxicated, just that you had a metabolite of some drug in your system. We see this quite often with marijuana. Frequent users, if something will show up in their system, even though they were not intoxicated at the time. So that's something that the state can often charge and people are confused about because they weren't intoxicated. It is a very frustrating law that we have to deal with, but it's still on the books in Indiana. And we see it all the time with states all around us having legalized marijuana. So it's something that we are looking to challenge, but right now it is still a charge in the state of Indiana. You can expect once you're charged with an OVWI, the court will set you for an initial hearing and then a series of pretrial conferences up until there's a resolution date, either of a trial or a plea agreement of some sort. So that's kind of the general path that will happen. The state may try to suspend your license while the case is pending. We have ways we can try to prevent that as well, especially if you do not refuse a chemical test. If you did refuse a chemical test, we'll take a slightly different path, do everything we can to get that lifted so that we can get you driving as soon as possible. We know for everyone the priorities when facing an OVWI charge are keep me out of jail and keep me driving. And so we will do everything in our power to make sure we can accomplish those goals for you. So if you have questions about your OVWI case, give us a call, 317-632-3642. Remember, always plead the fifth.